Dr. Sri Verma's
Right, my lord, I must say that it is not the contention of the central government. It is not A versus B. My lord, some of the states have filed their reply that state opposing the reference. There is neither supporting or opposing the reference. Questions are put. So I'm answering those questions that this is our interpretation. My interpretation is not that it is an absolute and unbridled right of the governor to sit endlessly for no reason on a bill. That's not the high-pitched argument which the central government would like to raise. B, the governor does have 4 options, my lord, to which I'll not labor much. Because, my lord, after having learned, my lord, heard, my lord, the illuminating arguments of Mr. Sibal, Mr. Subramaniam, Mr. Datar, I've also gone through the note of Dr. Singhvi, etc. Lord, substantially, Lord, all of us have covered, except, my lord, points where they somehow missed, my lord, some of the judgments, etc. I'm not going to repeat any of the judgments because I know I am at the stage of rejoinder. I have filed my written.
So, Gopal, Sangana Rao said there is no question of rejoinder.
Anyway.
You are saying this is only a reference.
Well, I'll not enter into that debate, my lord. It's unnecessary, my lord.
Technically, he's right. Technically, he's right. Technically, he's right. But I think, Malad, because the issues are complex, Malad, we have no.
Lord, it's not a question of, my lord, my being a petitioner,
yes,
they
exactly.
being a respondent, and therefore I am giving a rejoinder. It is a question of assisting the court that this is the view of the central government, this is the view of some state governments, these are the views of this another state governments, and if they have expressed certain views, their interpretations, Lord, then I am just reacting or responding to their, my lord. It cannot be taken, my lord, in that strict jacket rejoinder reply rejoinder argument.
Because it's not a list, my lord. Because it's not a list.
It's not a list, my lord.
Therefore, there is no rejoinder. But I think we should not object if the solicitor wants to.
Only an opinion.
No, my lord.
Not binding on anyone.
Lord, I would not reduce.
It is a report.
But we have had the perspective of 2 extreme views taken and argued by the 2 sides.
Your lordships are right.
The balance, we will have to bring it. I think we have seen the extreme views from both sides.
Correct. My lords, your lordships may, my lord, find.
It's a very enormous task that we have.
Your lordships, my lord, therefore.
And the task of 18,000 pages.
That's, my lord, that's a Herculean task.
Unfortunately, there is no summer vacation in between now and 24th November.
Yes, my lord, there is none. My lord, and your lordships.
The attorneys contribute only very little part of it. I said, I have contributed only very little part of it.
Yes.
Pages have gone up to 25,000, not 18,000. 25,000. Volume 5.62.
But, my lord, to be fair to everyone, we have not, none of us, my lord, have cited all judgments which are placed on record. My lord, possibly they are placed on record in case, my lord, it is required to be cited.
We are told of constitutional silence.
Yeah, yes, my lord. My lord, volume 1.9 may be taken, my lord, and I can assure your lordships, I am not going to read everything. I'll skip most of the paragraphs, but they are my submissions, my lord.
Another volume, no?
Yeah, my lord, it's a
Rejoinder volume.
rejoinder volume, my lord, a response, or my lord, I have termed it as a rejoinder.
Rejoinder submissions on behalf of the solicitor. Got it.
So this is the central government's interpretation, I'll put it that way, to the interpretation canvassed by some of the state governments. My lord, and I would, my lord, respectfully say, I would not reduce the august jurisdiction of this honorable court, that is advisory jurisdiction, of a mere giving a report which is not binding, which is not worth a piece of paper. My lord, no, your lordship's opinion, my lord, is a law declared, and I'll make that good. And your lordships can even declare, I'm repeating, your lordships can even declare that this particular judgment or the view expressed does not lay down the correct law. Your lordship can even overrule that. It's not just, my lord, a communication or conversation between the President of India and the Supreme Court of India. My lord, the President of India has, my lord, my lord, has sought your lordship's opinion, and your lordships are interpreting the constitution while giving that opinion. My lord, kindly come to page 746. My lord, these are the broad propositions, my lord, which are argued, and I'll deal with it, my lord, without repeating anything, my lord. And if your lordship finds any repetition, your lordships may, my lord, kindly tell me. I'll proceed further to the next point. My lord, the argument number 1, governors have no power to withhold a bill in any circumstances whatsoever. Number 2, the governor has no discretion in any circumstances whatsoever under Article 200, meaning thereby the moment the bill is presented before him, in every situation he is supposed to act in aid and advice of the Council of Ministers, meaning thereby, if I put it, paraphrase it in my own way, they have not argued in that way, that he is a postman with only two difference, that his car has a beacon and he has a bigger house. That's, my lord, constitutionally a flawed argument. Third, the governor therefore is not to apply his mind to the process. So this was an argument made. The action of the governor is judicially reviewable to the fullest extent. My lord, I have certain constitutional submissions to make, my lord, before your lordship, my lord, which I have already made, but some additional submissions, my lord, which I make, that it is not amenable to judicial review. Even if it is amenable to judicial review, it is not justiciable. And I'll give the reasons, my lord, in a nutshell. The governor is answerable like any other executive authority making any other routine administrative executive decision. My lord, this is again, my lord, in my respectful submission, constitutionally not correct, because as I'll show, my lord, from the scheme of the constitution, the legislative process starts from a particular article, my lord. Thereafter, it comes to introduction of the bill. Thereafter, how the bill travels, and it ends, the legislative process ends with the assent of the governor. Your lordships are aware, the governor is a part, he is a component of the legislative assembly, but he has no right to vote. He cannot preside over the meeting. But nonetheless, he is a part of the legislature because the legislative process commencing from introduction of bill culminates into the final step of legislative process under Article 200, when he gives his assent. And the last, the governor must act within a set time frame as provided for by the court, absent any constitutional provision. My lord, kindly turn the page over. My lord, I have, my lord, already narrated, but I am emphasizing, my lord, this oath of office, my lord, because your lordships are considering the powers, functions, duties, responsibilities, etc. of the governor. And there is one judgment which is not so far cited, for which as a prelude, I would like, my lord, your lordships to see which oath the governor and the president takes, which is, my lord, these are the only two functionaries for which, my lord, this specially defined oath is, my lord, contemplated in the Constitution, Article 159. I so and so do swear in the name of God that I'll faithfully execute the solemn affirm office of governor of so and so, will to the best of my ability preserve, protect, and defend the Constitution and the law. Lord, my first respectful submission is that there are certain implied discretions, which I will come to, my lord, little later. And one of the implied discretion, my lord, would flow from his duty to preserve, protect, and defend the Constitution. So now, please, my lord, come to Article 167, which is quoted at page 747. It shall be the duty of the chief minister of each state to communicate to the governor of the state all decisions of the Council of Ministers relating to the administration of the affairs of the state and proposals for the legislation, to furnish such information relating to the administrations of the affairs of the state and proposals for legislation as the governor may call for. You can even ask this how this particular government is functioning. And I'll, my lord, show Supreme Court, as your lordships have said, why this is the power conferred upon you. See, if the governor so requires to submit for the consideration of Council of Ministers any matter on which a decision has been taken by the minister, but which has not been considered by the council. He can say that such a decision of this magnitude, decision affecting the entire state or decision affecting the economy of the state could not have been decided by one individual minister. These are the responsibilities of the Honorable Chief Minister of the state. Lord, now in this context, please read the Constitution Bench judgment, which is so far not read, my lord. That is case of BP Singhal versus Union of India. Page 748, my lords. Lord, your lordships may see para 35 of this judgment. My lord, last line, which nothing, my lord, says much, it says the constitutional position. He thus occupies a high constitutional office with important constitutional functions and duties. Now, please see further. In state of Rajasthan versus Union of India, please mark, this is a 7-judge bench judgment. A constitution bench of this court described the proposition of the governor thus: the position of the governor as the constitutional head of a state, as a unit of the Indian Union, as well as the formal channel of communication between union and the state government, who is appointed under Article 155 of the Constitution by the President by warrant under his hand and seal, was also touched in the course of arguments before us. On the one hand, as the constitutional head of the state, he is ordinarily bound. Please mark, my lord. The argument was that he is always bound. 7 judges bench says ordinarily bound by reason of a constitutional convention by the advice of his council of ministers conveyed to him through the chief minister, barring very exceptional circumstances, among which may be pointed out by my learned brother Justice Bhagwati and Justice Krishna Iyer in Samser Singh case, a situation in which an appeal to the electorate by a dissolution is called for. On the other hand, as the defender of the Constitution, this is why I read the oath he takes, as a defender of the Constitution and the law and the watchdog of interest of the whole country and well-being of the people of his state in particular, the governor is vested with certain discretionary powers in exercise of which he can act independently. One of his independent functions is making of report to the union government, on the strength of which the presidential power under Article 356 of the Constitution could be exercised. Insofar as he acts in the larger interest of the people appointed by the president to defend the Constitution and the law, he acts as an observer on behalf of the union and has to keep a watch on how the administrative machinery and each organ of the constitutional government is working in the state. Unless he keeps such a watch over all governmental activities and the state of public feelings about them, he cannot satisfactorily discharge his function of making the report which may form the basis of the presidential satisfaction under Article 356(1). My lord, here the 7-judge bench reads the implied discretion that under certain circumstances, as a watchdog, as a representative of the union, as a representative of the president, he will have to have certain discretionary powers, and one of the illustrative power is Article 356. But further, this BP Singhal cites state of Karnataka, another 7-judge bench judgment. The governor of a state is appointed by the president and holds office. By state administration is carried on by him, etc., etc. My lord, your lordships may, my lord, kindly see. There are, my lord, your lordships can skip 38. 38. Another constitution, my lord, this is all quoted in BP Singhal. Another constitution bench of this court in Hargovind Pant versus Raghukul Tilak. My lord, please see, my lord, only the highlighted part. My lord, I have quoted everything so that I am not accused of selectively quoting, but what is relevant for the present purpose would be, my lord, in my submission, the highlighted part. The governor is the head of the state and holds a high constitutional office which carries with it important constitutional functions and duties, and he cannot, therefore, even by stretching the language to a breaking point, be regarded as an employee or servant of the government of India. My Lord, not in these words, but my Lord, Dr. Singhvi virtually said that he is just, my Lord, a nobody who is sitting there on behalf of Union of India. He is not amenable to the direction of the government of India, nor is he accountable to them for the manner in which he carries out his functions and duties. He is an independent constitutional office which is not subject to the control of government of India. He is constitutionally the head of the power of the state, and without whose assent there can be no legislation in exercise of the legislative power of the state. Grant of assent is exercise of legislative power of the state. And this would be relevant, my lord, when your lordship are pleased to examine the justiciability and locus of filing writ petitions which is conferred by, my lord, this honorable court. There can therefore be no doubt that the office of the governor is not an employment under the government of India, etc. 5 is important. It is impossible to hold that governor is under the control of the government of India. His office is not subordinate or subservient to the government of India. He is not amenable to the directions of the government of India, nor is he accountable to them for the manner in which he carries out his functions and duties. Then, my lord, Rameshwar Prasad is quoted. My lord, this is again, my lord, constitution bench, but I'm skipping para 39 and directly coming to para 40. My lord, this would be, my lord, assisting your lordships, my lord, immensely. It is thus evident that a governor has a dual role. The first is that of a constitutional head of the state, bound by the aid and advice of his council of ministers. My lord, I am not disputing. Normally, ordinarily, the governor will have to act in aid and advice of the council of ministers. As my lord stated by Mr. Singhvi, he is not a super chief minister, neither expected to be super chief minister. That's not the role envisaged under the constitution. The first is that of a constitutional head of the state bound by the aid and advice of his ministers. The second is to function as a vital link between the union government and the state government. In certain special emergent situations, he may also act as a special representative of the union government.
That is during the period of emergency.
No, my lords. My lord, I'll just give an example. I was going to give an example, my lord. A very, very good example. If we take away, if your lordships, my lord, read that there is no discretion, what happens? I'll take, my lord, there is one reference regarding Punjab water dispute. My lord, in Punjab water dispute, an agreement was entered into by Government of India, State of Punjab, State of Haryana, State of Rajasthan. The part of the water was going to Pakistan also, so it had cross-border implication also. It had federal issues also. It was affecting more than one states also. That agreement was sought to be cancelled by way of an act of the legislature. That now the legislature says that we will not be bound by this agreement. The governor, my lord, granted his assent. Kindly see, my lord, if discretion is not read, what would happen? Thereafter, my lord, State of Punjab filed a suit. I'm giving a brief idea, my lord. I'll read some of the. Can I read it now, my lord, so that your lordship's question is answered, my lord? Kindly have a look at, my lord, that State of Punjab judgment. Volume 5.24, page 9357. But ultimately, what I am suggesting is that in a situation of this nature, he is not only entitled, he is duty bound to withhold the asset or refer it to the president. And that council of ministers will never advise him to do. Lord, kindly see para 2. Lord, this is the reference. Lord, at page 9360. Lord, this is quoting, Lord, ultimately the Honorable President made a reference to your Lordships, Lord, that under these circumstances, what will be the correct position of law? Lord, please see third, whereas while at the time of signing, I'm sorry, 2. I'm sorry, my Lord, it's my page, starts at page 9357. I'm at 9360. The beginning, para 2, the second recital. Whereas the Indus Water Treaty 1960 was entered into between the Government of India and Pakistan on 19th September 1960, under which India is entitled to the free unrestricted use of water of Ravi, Bias and Satluj till they finally cross into Pakistan. Whereas while at the time of signing, the waters of Satluj had already been planned to be utilized by the Bhakra Nangal project, the surplus flow of rivers Ravi and Bias over and above the pre-partition use was allocated by agreement in 1955 between the states concerned, Punjab, Rajasthan, Jammu and Kashmir. My Lord, Punjab was undivided at that point of time. My Lord, please come to page 9361. Thereafter, my Lord, Haryana was separated from Punjab, and my Lord, another agreement comes. Whereas the state of Punjab, Haryana and Rajasthan entered into an agreement dated 31st December 81. I'm sorry.
December 1980.
Yes, my Lord.
Based upon that, suit was filed, suit decree by Supreme Court. And to get legal out of that suit, the Punjab passed the check.
First, my Lord, first act was passed. Thereafter, your Lordships are right, another act was passed. Lord, Punjab, Haryana, Rajasthan and Delhi. Lord, there was an agreement that this is how the water would be shared. Now, please come to para 5 at page 9363. Lord, the state of Punjab, Haryana and Rajasthan entered into an agreement dated so and so, which has been referred to herein above in the reference, by virtue of which the Punjab, Haryana, Rajasthan, in view of overall national interest and optimum utilization of Ravi and Bias waters, had agreed on relocation of Ravi and Bias waters. But as the said agreement was not being acted upon by the state of Punjab, the state of Haryana had instituted suit number 6 of 96 before this court under Article 131 of the Constitution of India. Now, para 7. The state of Punjab did, then there was a judicial order passed by your Lordships in 131 in the suit filed by the state of.
Was decree.
Yes. Now, please come to
January 2002.
my Lord, sorry. Para 7. The state of Punjab did not comply with the decree dated so and so. Good.
Justice Venkatramaya Malaz presided over that tribunal, the Ravi Bias tribunal. And Malaz Haryana got a share, as your Lordship knows, not implemented by Punjab, which resulted in all these suits, Malaz. That's what really happened.
Lord, para 936.
Nani Palkiwala and I represented Haryana.
Lord, para 6.
Punjab was represented.
Lord, para 12 may kindly be seen. At this juncture, we would like to refer to certain unwarranted developments which took place after we started hearing this reference. The legislature for the state of Punjab introduced Punjab Satluj Yamuna Link Canal Land Transfer of Proprietary Rights Bill 2016. No assent of the governor is received till date. He is under, my lord, not only entitled, he is under a duty in a circumstances like this, not to give assent. Date, and therefore it is not a legislation and will remain a bill passed by the Legislative Assembly. By virtue of the aforesaid legislation, the state of Punjab proposed to act in clear violation of agreement dated so and so, which has been referred to in the reference. Lord, thereafter, my lord, the court says that this ought not to have been done, and non-grant of assent was approved. Lord, these are the circumstances where it is not possible to act merely on the aid and advice of the Council of Ministers. He is under an obligation to defend the Constitution, to preserve the Constitution, to act in his own discretion, and not to grant, my lord. Thereafter, my lord, he refers this to the President, and the Honorable President, my lord, gives, my lord, makes a reference. Now, my lord, coming back to my submission, my lord, at page 750.
You are relying only on this part of the.
This part, my lord, that sometimes, my lord, there can be circumstances where you will not get aid and advice, my lord, and I am not saying that every Council of Ministers would act mala fide.
Context with the question referred. Is there any question referred which is of any relevance to us?
No, my lord, it was apropos my lord's question.
No, we are just asking, in this context, is there anything relatable to this in the questions referred at 12936?
Lord, these are the questions where, my lord, fact specific of that case,
President referred.
whether the Punjab termination of agreement and the provisions thereof are in accordance with provisions of the Constitution of India.
That's the first act.
Yes. Whether the Punjab termination of agreements and the provisions thereof are in accordance with provisions of Section 14 of Interstate Water Dispute Act, Section so and so. Look, this was a case where federal issue was involved, rights of other neighboring states was involved, cross-border implication was involved, etc. And your lordship's pendency of the suit before your lordships, and the judicial order was involved. And the government of the day, but I'm not saying that the Council of Ministers would always act mala fide, but the government of the day, considering the situation prevailing at that point of time, would never advise the governor not to grant assent. He will have to, under the circumstances, preserve and protect the Constitution on his own discretion. That is the respectful submission. Then, my lord, para 40. It is thus evident that governor has a dual role. The first is that of a constitutional head of the state, bound by the aid and advice of the ministers. The second is to function as a vital link between union government and the state government. In certain special emergent situations, he may also act as a special representative of the union government, like in Punjab. Not only, my lord, in 356. He can ask the president that there is something being done which will have implications on the neighboring countries also and other states also. That is the emergent situation, my lord. Inter alia 356. He is required to discharge the functions related to his different roles harmoniously, assessing the scope and ambit of each role properly. He is not an employee of the government, nor the agent of the party in power, nor required to act under the dictates of political parties. There may be occasions where he may have to be an impartial or neutral umpire where the views of the union government and the state governments are in conflict. Please mark this. His peculiar position arises from the fact that the Indian Constitution is quasi-federal. Then, my lord, state of Karnataka, my lord, kindly read last 4 lines. Leaving the functions of the judiciary apart, by and large, the legislative and the executive functions of the center and the states have been defined and distributed. But even so, though it all runs an overall thread of or reign in the hands of center in both the fields. My lord, pro-center tilt of the Constitution, my lord, as it is submitted or stated in many judgments. My lord, kindly turn the page over 751, para 44. My lord, again, this is, my lord, a reference of state of Karnataka judgment, my lord, which is, my lord, 7 judge. In such a scenario of myriad policies, ideologies, agendas, in the shifting sense of political coalitions. Well, kindly see the prophetic words used in reference to the governor's role. Myriad policies, ideologies, agendas in shifting sense of political coalitions, there is no question of union government having governors who are in sync with its mandate and policies. Governors are not expected or required to implement the policies of the government or popular mandates. Their constitutional role is clearly defined and bears very limited political overtones. We have already noted that governor is not the agent of the or the employee of the union government. As the constitutional head of the state, many a time he may be expressing views of the state government which may be neither his own nor that of the center. For example, when he delivers the special address under section article 176, it is always prepared by the council of ministers, the governor, the government. A reputed elderman, statesman, able administrators and eminent personalities with maturity and experience are expected to be appointed as governors. While some of them may come from a political background, once they are appointed as governors, they owe their allegiance and loyalty to the constitution and not to any political party, and are required to preserve, protect, and defend the constitution. See, terms of oath or affirmation by the governor under Article 159. My lord, almost, my lord, many judgments say that his duty has to be read in tune with the oath he takes. Like the president, governors are expected to be apolitical, discharging purely constitutional functions, irrespective of their earlier politically active. My lord, as I will point out a little later, my lord, we should be proud as citizens of this country that the constitution and the aspirations of the constitutional framers have withstood, my lord, this expectation. I'll give, my lord, the empirical data. Irrespective of the government in power in the center, right from, my lord, 1970, irrespective of the government in power in various state governments, my lord, the governors, except few aberrations, have acted, my lord, the way the Supreme Court has desired them to act. Lord, please kindly now further see state of Karnataka, my lord. Again, Lord, I am reading at page 752, para 44. However, we may examine the express provisions of our constitution relating to the organs of government in states, which no doubt give the appearance of full-fledged separate states for certain purposes. Each state has its own governor exercising the executive power of that state. But all governors, although undertaking to devote themselves to the service and well-being of the people of their respective states, owe an undivided allegiance to the constitution and the laws. This is where, my lord, the implied power comes, and exceptional circumstances where aid and advice they cannot follow if it is unconstitutional or contrary to the constitution. Now, my lord, please come to para 753. Page 753. My lord, I'm skipping. Lord, page 753, I'm not reading it. I'll just, my lord, point out orally. Lord, some of the submissions, Lord, compared the Honorable President of India under our Constitution Lord, I think the expenditure which, my lord, either I was to bear or Mr. Sibal was to bear, Lord, should be borne by Dr. Singh.
That is why he always takes the corner seat, so that he can easily slip away.
Yes.
From
The
front,
reason
if he
being-
slips away, then everyone will notice
The
it.
reason being, the,
Lack of natural justice, I don't know the context. Ex parte
so
comment.
you don't need to,
ex parte
you
comment.
say, all right, I'll bear the expenditure. You don't need to know the context. Lord, because the other side nodal council is like my daughter. This side nodal council is like
Individual
Mr. Sibbal's son. Mr. Sibbal's son also. So, my lord, I better, Dr. Singhvi, who has always been earning throughout this, my lord, reference, should bear the expenditure.
So, but in this matter, he is appearing for how many states?
Only one state. There are people appearing for more than one state here. But I am happy to share whatever expensive analysis says or.
Not share.
No, not fair.
You have to bear.
Not share.
Without asking about the details also.
No.
But I trust him that he
No,
won't be unfair.
I said that I'll bear it. Now, Mr. Singh, Mr. Sibbal said, no, I will bear it. Now you're reduced to sharing. This is not a soldier.
Tax exemption.
My lord,
Don't see tax
this
exemption.
is the third option, my lord, he is and
No, but that will be counted as an expenditure.
therefore I was going to say this,
Will be.
that this option which is exercising would be referred to somewhere else.
No, he is the highest taxpayer.
Yes. Highest individual taxpayer.
Maximum brickbats to them.
Anyway, my lord, on the lighter side, my lord. My lord, Crown, my lord, some of them compared, my lord, only 2 minutes on this, nothing more than that. That President of India is like a British Crown. My lord, Mr. Datar even read some judgments that British Crown cannot withhold, cannot do this, cannot do that. My lord, we will have to understand, my lord, that our constitution borrows a broad skeleton of parliamentary democracy as available in England. We have not blindly followed it. Crown is a hereditary crown. Queen's son will succeed irrespective of his qualification or acceptability in the nation. He would be the king. While our president is elected by the entire nation. Because his voters are elected people representing the will and wish of the entire nation. He is supposed to act as per the aid and advice of Council of Ministers, who are all again elected, and they owe responsibility and answerability to both the houses of parliament. This is the position of President of India, can never be compared with the crown, British crown. Lord, that is what I have elaborated. Lord, essentially, my lord, before I switch over to another topic, my lord, essentially, my lord, the governor's role will have to be as a guardian of the constitution, protector of the constitution, a representative of Union of India, a person who takes in particular or peculiar circumstances interest of the entire nation because he represents the President of India, and everything he should do in consultation and collaboration with the Council of Ministers. Lord, your Lordships would recall yesterday when Mr. K.K. Venugopal was arguing, Lord, he gave a list of dates in case of Kerala. And he in fact said that this is how it should function. I agree, fully agree with him, that the governor calls upon the chief minister over tea, some issues are discussed, thereafter, my lord, there is some other discussion, other meeting, other consultations. This is how, my lord, the constitution works, and this is how the constitution has worked. I'll show that with empirical data, that this is how the constitution has worked. Now we are raising a false alarm that there is a need to do something, Lord, which I will, Lord, try and demolish. Now, Lord, please come.
How can you say that if the bills are pending before the governor for 4 years?
I'll answer that. It is a part of, it is a part of my submissions. I am not justifying indefinite pending of pendency of the bills. I am respectfully urging there cannot be any straitjacket timeline because each bill depends upon the facts of each case. I'll come to that and I'll show that such.
This we can appreciate, that there can't be any specific timeline. Your one line of argument is that he has a power to withhold the bill permanently.
Yes, Yes, my lord, that's my argument. That's my next point. That's my next point, my lord. In my submission, the governor, instead of referring the bill to the president in Punjab, he should have withheld it. That this bill can never be passed. And I'll give the empirical data right from 1970 till date. Right from 1970 till date, as per the data available with me, only 20 bills across the nation are withheld by different governors. Out of 17,000 bills, only 20. So this is not a power, my lord, which is to be exercised at a drop of the hat, that I don't like it. It's not in tune with the political policy of the party in power in the central government, but something which is so atrociously unconstitutional.
It was withheld by stating that I am not giving an assent, or it was. just
I am
not
withholding.
communicated.
I'm withholding.
Therefore, he has rejected this.
Withholding is an option, and your lordships, my lord, may kindly consider.
You also have the data where bills are sent and not cleared for years.
My lord, I have the data which shows that 90% of the bills, the assent is given within 1 month. 90% of the bill. Then second column, I will come to within 3 months. The third column, within maximum 6 months. And more than 6 months are few.
Obviously, when I gave much lesser data for things.
No, you were on
will
a
give it.
state-specific
Giving
data.
empirical data now, this can't be allowed both ways.
I
Please
said
take
so.
my data also, but that's not fair. My learned friend objected very vehemently, even when I opened. And I'm giving you actual live instances directly year by year for 3 states. It can't be one sided.
Anyway, my lord, anyway.
Can't be one
Bengal,
sided.
Malad, all the bills are more than 3-4 years, Malad. I didn't give any data because your lordship said don't give data. Now you can't give, Malad, all this is happening after 2014, not before that.
Oh, I'm so sorry. My learned friend possibly is not aware. I am praising your government also. 70, right? From 1970 till date.
I know that you should praise because no governor acted like this. You're absolutely right.
No, I know, but
You're
but unfortunately, I am not a politician. I'm only a lawyer. So I'll not make any political
more of a
comment. No, I have
politician than I
many,
am.
I have
Don't
many
get into all
comments
this.
to offer, my lord, but
Don't
I'll
get
be
into all this.
only a lawyer. But right from 1970 till 2025, which includes the period from 2014 to 25, only was my lord wanting to give his state-specific problems. I'm not giving you the problems. I'm giving you the empirical data, how the constitution has worked since last, my lord, 1970, since last 55 years.
Maybe we are not going into that question.
No, my lord, I'll show that, my lord. It must be shown. Kindly, my lord, have a
No,
look
but
at
then if it has to be shown, then we'll have to see that at all. No, it can't be one-sided.
only, my lord, if the lordship ignores this, lordship may ignore this.
Because if we are not permitted them to give any data, you
The
should also not give any data.
Lordships would immediately see,
But that's not fair.
your lordships would immediately know the difference between the data they want to show. This is not, my lord, figures.
No, that's not fair.
My lord, would your lordships not like to even see
No.
to reject it?
If you objected to their sharing our data, then the same analogy should apply to you also.
My lord, kindly give me 2 minutes, uninterrupted 2 minutes. My lord,
Then
give me,
we'll have to give them an opportunity to.
okay, please do that. Kindly, my lord.
Having objected that, now you can't turn back and say that I want to give the empirical data.
My lord, kindly, my lord, appreciate something, my lord, which is,
So you argue on the questions of law, but not.
I am
not the
arguing on a
data.
question of law, but the empirical data suggest. My lord, give me, my lord, a minute. Your lordships can ignore this argument completely. My lord, from 1970, we received data only on
Solicitor, it will not be fair to go into that question because
ignore it, my lords. Give me a minute, my lord.
then why argue it?
Give me a minute. Out of 25 states, right?
Forget, we will not go into that question. We will
No,
only
no,
answer the
no.
questions which are raised before us.
My lord, your
Yeah,
lordship-
otherwise then we'll be unnecessarily going into the data then. We'll have to,
I'm, my lord,
Yeah,
your lordship, my lord, my difficulty is I'm unable to communicate what I'm trying to communicate. they wanted to present their problem, that in my
Not
case,
problem. They wanted to present as to in how many cases their bills have been. Wow,
the presence is noted for today.
Mehta, you need not be.
they wanted to
You are
present the data
critical. You
in
oppose
respect,
me and now you're
in
doing the
respect
same
of the states to which they are representing, as to for how many days and how many years the numbers of bills are pending as in the governor. So you objected to that.
Lord,
So
please,
now, you objected to presenting such a data.
Lord,
Now
I
you
am,
can't say that I will present a data on the basis of all India and.
Lord, 90% of the bills are assented within 1 month.
Maybe.
How is that relevant?
Relevant for
today?
that.
Why are
Relevant
you
for that.
making that submission? Just
And only 20 bills out of 55 years are withheld, which includes these 7 bills.
nation is continuing with the constitution and the democracy for 75 years.
Yes,
Irrespective whether 50% bills have been withheld,
difficulty is this.
90% bills have been withheld or whatever.
Lord,
The
forget,
states are also
forget the
functioning.
facts. I'll tell
System
you.
is
about
also
the
functioning.
reason.
Leave that aspect.
Forget the facts. Forget the facts.
We are proud of our constitution.
We are proud of the
When we see
constitution.
what has
my
been
lord.
happening in the neighboring state, like what happened in Nepal yesterday.
Yes, my lord. Yes, my lord.
Earlier Bangladesh.
Almost, my lord, yes.
Nepal, it just happened 2 days back.
I am, he argued felt necessities, felt necessities. His note was.
But then you are
given-
also bringing factual.
No. Felt necessities. He says these are felt necessities. So to respond to felt necessities in his bill, I'm saying that earlier also such kind of issues must be arising. But the states were not being advised to rush to the Supreme Court. They were settled. 1 month.
Were
90
ill-advised then, if they are better advised today, why should we go into that question? We are not going into that question.
Don't go into that question. But
What happened
my lord,
prior to 2014 and what is happening later after 2014 is not relevant for us. We are not going to that.
We are only going to answer.
No, I'm sorry, my lord. My learned friend unfortunately brought 2014. My data is 1970 onwards.
Not in my government.
1970 onwards.
Anyway, let us go.
It is
Let us-
Government of India.
So, solicitor,
For
let-
him, it may be
let us-
2014 and
let us
pre-2014.
Let us restrict ourselves to the.
Lord, I'll restrict it, but I strongly object to this kind of division.
I also object to what you said.
That 2014, what is
Politicians
this?
and all.
Both of you may record your objections outside the court. You may argue
Lord,
that
it's not in, we are one nation, but not one continuing government. Government is always in continuance.
Mr. Solicitor, the point is whether one bill is withheld in the past 1970 to 2025 or 1,000 bill withheld. That may not be relevant.
Whether power of withhold is there or not.
the power of withholding best or not.
This,
Power of withholding.
this
has to be the
fire in the auditorium argument that something is happening. Do something, felt necessity. Therefore, I am saying.
No,
there is
we
no
did not permit their argument to be made.
we will not.
The-
We did not permit them to
Felt
make.
necessity was an argument which
We- so we-
I leave it at that, my lord. I can't argue.
And we did not permit them, we will not permit you also.
Your lordship did not. But he read that.
No, he did not read. We did not permit him to read.
No, not facts. I'm sorry, my lord. Phonetically similar words. Felt necessities, not facts. Felt necessities. That's what, my lord, his argument.
Leave it at that and start. after.
Yes, my lord. Now kindly come to para 15. Kindly come to para 15. Article 200 states that when a bill is, my lord, kindly see, my lord, when a bill is presented, the governor shall declare either that he assents to the bill or that he withholds assent therefrom, or that he reserves the bill for the consideration of the president or return with the message. Now, my lord, the way they want to read it and way, my lord, the 3-judge bench in Punjab has read it. If that is the correct interpretation, the article will have to be read with this amendment. Kindly see, when a bill has been presented so-and-so, the governor shall declare either that he assents to the bill or that he reserves the bill for the consideration of the president, provided that government may, as soon as possible, after presentation so-and-so, and last, shall not withhold, should be assent therefrom. Assent thereto. This is how it would read. My lord, kindly appreciate one thing, and my lord, kindly, my lord, come back to, my lord, my initial argument and compare it with their argument. My lord, their argument was, and this is, my lord, very crucial point, my lord, in my respectful submission, that the word withhold is used in the sense of a temporary deferment, that I defer and return the bill to the house. Correct, my lords? The word withhold is used in the same article twice. First, he assents to the bill, or that he withholds assent therefrom, or that he reserves the bill. Now I read it as they read it. Withhold assents to the bill, or temporarily defers the assent therefrom, or he reserves the bill to the president. And then according to Punjab judgment, and it is their argument, that he will have to resort to proviso. My lord, what meaning, I'm posing a question to myself, we will give to the last part, my lord? If the bill is passed in the proviso, first proviso, if the bill is passed again by the House or Houses with or without amendment and presented to the governor for assent, the governor shall not withhold. Lord, this is definitely a final withholding. This withholding can never be a temporary deferment. One word used in the same article cannot have two different meanings. I hope, my lord, I am able to. I'll, my lord, again, my lord, kindly allow me to make myself more clear. My lord, your lordships may, my lord, read with me the first main part. When a bill has been passed by the Legislative Assembly, so and so, the governor shall declare either that he assents to the bill. Pause here for a minute. Now I am reading the way they read it. That deferment, withholding here is temporary withholding or temporary deferring till
The proviso is exhausted.
it is returned to the House. So I am reading it, or may temporarily defer or withhold the bill. Correct, my lords? So temporary deferment is withhold according to Punjab judgment and my learned friends, my lord, very illuminating, my lord, contention. Now, my lord, what meaning we will give, my lord, apropos, my lord, Justice Narasimha's, my lord, query. Please come to the first proviso, last line. And if the bill is passed again by the House of or Houses with or without amendment and presented to the governor for assent, the governor shall not withhold assent therefrom. Lord, this withhold cannot be temporary deferment. It doesn't say that governor will have to assent. Lord, both the term withhold is used in the main part as well as in the first proviso. It cannot mean temporary withholding or temporary deferment in the main part and final withholding in the proviso. Along with, my lord, I have read, my lord, withhold months means it falls through, and falls through, my lord, I'll come to that. My lord, Justice Narasimha, my lord, also pointed out that this is not a word used in the Constitution. My lords are right. But the word falls through has a significant connotation even in the Constituent Assembly debates. When the amendment is not passed, that is the expression very consciously used by the Constitution benches subsequently. That if it is withheld, the bill falls through, meaning thereby it ceases to be a bill. It will not become an act.
But it is not passed by the Constituent Assembly.
No, I'm slightly on a different point, my lord. Maybe I'm going a little fast.
As far as constitutional amendments are concerned,
I'm not on amendment. Ignore that last. I'll come to that little later. Ignore Constituent Assembly debate part.
no, you said that fall through is coming from the Constituent Assembly debate. There it comes from the context that whenever any amendment is suggested, and if the amendment is not accepted, then that amendment falls through.
Meaning thereby it ceases to be.
It ceases to be.
So that
But
phrase,
that analogy can be applied to the bill which is passed by the legislature.
bill, kindly appreciate the distinction. The Constituent Assembly amendments were not to be approved or assented to by someone. Therefore, it used to fall through there. Here, there are stages that it becomes a bill. Then if it is assented to, nothing happens. But if he withholds, the expression which is used is borrowed from Constituent Assembly debates, that it falls through. I'll come to that, my lord, little later. My lord, now please see para 18, my lord, at page 755. The interpretation can be construed from a different angle if the word, my lord, I have already argued that, my lord, I will not trouble your lordships with that, my lord. Please come to para 21. My lord, the argument was that you take the spirit of the Constitution. Spirit of the Constitution, according to them, as understood by me, is that governor has to do nothing. He has to act as per the aid and advice. My lord, that violates the very fundamental principles that there are certain implied discretions which the governor can exercise. But to come out of that, they say that look at the spirit of the Constitution. My lord, my learned friend, my lord, I have requested him to, my lord, elaborate on that. But there is one.
For rejoinder, everybody will not be permitted.
I mean, your lordship sense.
Then you will give you time, but not everyone.
I mean, your lordship sense. But I didn't object.
Suppose after the solicitor, then I have my final say on the matter.
We'll give you time till
Your lordship.
1 o'clock tomorrow.
Yes, yes. Not all of us can conclude by
Not
1
all of us. It can be a debate sort of. Yeah. You are appearing for the center?
It will have to be a debate.
No, sorry. Whatever is the stand of the other states have already given their opinion.
Otherwise, come and sit here, my lord.
That privilege is only for Mr. Amit Kumar.
My lord, I'll not answer that, my lord. That's a separate privilege. Let it be, my lord. Let it be. My lord, this argument is debated in, my lord, this Keshav Madhav Menon versus Bombay in, my lord, 7 judge cases, 6 judges. 7 judges, no, I'm sorry. 7 judges, my lord.
Earlier judgment, some judgments were by 4 judges also.
4 and 6, yes.
Yes. No, this is not 7. I have said 6, but it's a mistake. Kindly, my lord, at page 756.
It is 7.
7. It is 7 judges. Please come to para 13 on that. Yes. An argument founded on what is claimed to be the spirit of the Constitution is always attractive, for it has a powerful appeal to sentiment and emotion, but a court of law has to gather the spirit of the Constitution from the language of the Constitution. What one may believe or think to be the spirit of the Constitution cannot prevail if the language of the Constitution does not support that view. My lord, the argument, which was a very catchy and very, my lord, kind of a, my lord, as they say, my lord, emotional argument was that the bill passed by the majority of the House. How can that be withheld or killed by one individual? Not if the text, the textual meaning permits, it can be done. It is for your lordships to consider whether it can be done routinely. But I wanted to show that in 55 years, it is done 20 times. Various governments, various combinations, one party in center, another party in state, third party in center, fourth party in state. But Constitution has withstood. And there are circumstances. I'll give that example because I'll when I come to that point, my lord, I'll give that example. My lord, kindly, my lord, turn the page over and come to para 24. Para 24. My lord, this is felt necessities. My lord, what I wanted to show from the empirical data that the Constitution with the present 200, with the present interpretation of 200 has withstood the test of time. 1 or 2 states recently, in last few years, maybe because of the governor's inaction or for whatever reason, I'm not going into it. They cannot declare a felt necessity to amend the Constitution. And even if felt necessity is there, The remedy is not to amend the constitution by a judgment. So please have a look at para 24. The argument of the other side on the issue of constitutional interpretation, specifically the reliance on felt necessities and purposive, non-conflict based interpretation, deserves a closer analysis. While the said submissions appear to be non-controversial and appealing, there exists an inherent contradiction in the submission advance. The following factors may be noted in this regard. It is submitted that felt necessities and purposive interpretation necessitate a collaborative and effective constitutional role for all authorities. The doctrine of felt necessities is a call to construe the constitution in a purposive, dynamic, and forward-looking manner. Thus, any constitutional interpretation ought not to immobilize one constitutional actor while exalting another. Look, collaboration is possible if I have some powers, my learned friend has some powers, and we sit together. I have no powers. I'm supposed to, according to them, act as only what he says. Then what collaboration? What consultation? But why have four options? A living and purposive reading supports a model in which constitution functionaries engage with each other in good faith to realize constitutional objectives. The felt necessities of our times, including frequent inter-institutional friction, reinforce the need for constitutional practice that enables reasoned consultation and principled participation rather than a one-sided insistence that any role other than a mere mechanical signature by the governor is impermissible. This is where I am suggesting a balance. They are on an extreme argument that governor is merely a signatory. He can do nothing on his own. But at the same time, they also argue that there should be a collaborative and consultative exercise. What collaboration and what consultation if I have to sign without anything at my discretion? And my lord, this has been going on since 55 years. The chief minister is called, the minister concerned is called, there are dialogues, there are debates, there are exchange of views. Sometimes, my lord, I'll just give you an example. A popular feeling in the state requires the legislative assembly to pass a particular bill, which even the elected leader knows that it's not in the interest of the state. They might advise the governor, my lord, informally to keep it pending till the situation cools down. They might request the governor to withhold that bill. Well, there are several contingencies, several situations, which we will not be able to identify, visualize, or illustrate. But going further, 26, it seems that having found either textually or contextually, no other meaning is capable of being given, the states opposing the stand of the union makes a fallback argument of felt necessities and purposive interpretation. First, the term felt necessities is a subjective term. No subjective term can provide guidance for constitutional interpretation. The issues which have been arising in past with regard to the position of governor vis-a-vis the Council of Ministers have always been arising after the Constitution came into force. Such issues have not cropped up suddenly, which can permit any state to argue felt necessity. It is submitted that the Union of India fully accepts the constitutional proposition that the exercise of functions by the governor and the Council of Ministers must be collaborative and consultative. However, based upon perceived felt necessities of 2 or 3 states, rather than taking the correct political process, which so far has been adopted by all governments of all color. 2 or 3 states, it will not be permissible to interpret the constitution so as to distort not only the text, but even the intent and purpose of Article 200 and 201. In the same vein, the doctrine of felt necessities must also be looked at through a different lens. It cannot be the case that the judiciary is the only organ to determine the felt necessities of time and interpret the law accordingly. The other co-equal organs also engage in a test of enacting and implementing the law according to the felt necessities of time. Therefore, the parliament in its constituent power is equally well placed to amend the constitution to meet the felt necessities of time. Lord, that does not mean, my lord, that every state would come before your lordships, reduce the highest judiciary of the country to, my lord, if I may be permitted to say so, the position of a headmaster and say that this student is not doing it, tell him to do it. That's not, my lord, the role of this honorable court. There are political processes, there are consultative processes. The chief ministers of one particular color would go and meet the president of India, would go and meet the prime minister of India, and problems are solved. More and more cases are not coming before your lordships, not because problems are not arising, but because the problems are solved the way in which in a democratic polity they are required to be solved outside the courtroom. Now, therefore, I say that 90% of the bills are passed, assented to within 1 month. And if I go total, Lord, almost 95+% bills are passed in 3 months. Right from 1970 till date, my lord, 55 years. This is how the constitution has operated. My lord, then there are some foreign judgments, my lord, which I will definitely skip. Because there are certain things, my lord, which makes the larger bench incomplete. My lord, this is one of them, my lord, citing of judgments of other jurisdictions, my lord, which I'll skip. Lord, then argument was that you please give the interpretation to the constitution to make it workable. And according to the states, the workable would mean giving status to the governor of mere signatory and becoming an ornamental head of the state. Though, my lord, I have pointed out that the chief minister is under a constitutional obligation to go and tell him what is going on. The governor can call him and ask him what is going on. So there are 4 options, my lord, which all larger bench judgments, my lord, have said that these are the options available. And the very fact that options are available means options are available to the governor. Options are not available to the council of ministers. My lord, if there is a repugnancy, apparent repugnancy, my lord, which council of minister would advise the governor that no, there is a repugnancy, don't give assent to the bill? He will have to, my lord, in exercise of his duty to protect and preserve the constitution, say that no, I cannot assent to this bill. My lord, please come to the next page, para 35. My lord, I am skipping those paragraphs, my lord, which I am paraphrasing in nutshell, so that, my lord, others can, my lord, assist the court. 35. The argue.
There is no one to assist the court except you and the attorney. Otherwise,
with 2 of us. My lord. No, it was not, my lord, my.
Otherwise, those states will say that we will also say something in rejoinder.
When I say other means other than me, my lord, but the learned attorney. My lord, that's not.
So you said others. So
You want to include the others on your left, huh?
My lord, my difficulty is they do not understand, my lord, how to get a right of hearing. They are sitting at the wrong place.
no. We have given them all of them. We have given them only what opportunity.
Not, my lord, I could not convey the humor, my lord, what I wanted to convey.
It is except Mr. Amit Kumar who.
Anil Kumar is not the subject matter of my humor.
Amit Kumar.
Amit Kumar is not the subject matter of my humor, my lord. I could not convey, my lord. I'll convey it at a later point of time. Let's leave it at that. Lord, para 35. To argue that collaboration requires one organ to have no meaningful input is contrary. It also misunderstands that collaboration can occur only where there is a space for reasoned consultation and the articulation of principled disagreement followed by resolution, it is further submitted that the collaboration or dialogue can never be one-way street. It can only work if there are two co-equal branches of constitutional actors who are willing to listen to each other and are mutually committed to such a collaborative exercise. The governor, you have to do nothing. You are a postman. Whatever we tell you, you either grant assent, then sign it. Withhold assent, sign the withholding. Return it to the house, you return it. Refer it to the president, you refer it. And then, my lord, every judgment says that the exercise should be collaborative exercise. My lord, therefore, I say collaborative exercise necessarily imply co-equal constitutional organs. There cannot be, my lord, imbalance of functions. But I'm not saying power imbalance. But one has nothing to say and another has everything to say, then there is no collaboration, there is no consultation. It is submitted that further the office of the governor carries a limited but real space for statesmanship with constitutional bounds. My lord, kindly read, my lord, this is what, my lord, your lordship, my lord, this is what Justice Narasimha said, that both sides have given extremes. Lord, I am just giving, my lord, kind of a neutral interpretation as according to me. Ultimately, what your lordship decides would be the neutral. But this is how, my lord, I perceive the constitutional scheme to be. Anyway, my lord, I have learned to ignore, my lord, certain things. It is submitted further that office of the governor carries, because I wanted to say, my lord, laugh something, my lord, after giving some incident in 70s, but I don't want to go into it. Let us be constitutional debate. My lord.
Yes.
I don't want to contest elections. The Constituent Assembly's expectation that the governor would function as a friend
We'll know the outcome very soon, Malathi, we did.
pardon.
I said, I wish you do contest elections one day.
No, it's very difficult. My lord, I know. In Lok Sabha election, it's, my lord, we may say that they are politicians. To contest a Lok Sabha election is very, very, very difficult in the present times, my lord. The voter is a very smart voter, whether he is a doctorate or he is an illiterate farmer. Nobody can be taken him for, nobody can take him for a ride. And that is, my lord, the strength of our democracy. Kindly, my lord, appreciate, and I always feel proud of it. When Mrs. Gandhi imposed emergency, not a political argument, Lord, the people, Lord, they always, the name, my lord, agitates them. Lord, when they, but I'm going to say something other than that. They'll make them happy because I'm neutral. When she imposed emergency, the people, my lord, taught such a lesson that not only the party lost, she lost her seat. Janta government came. They could not manage the government. They could not manage the administration. The same people, within 3 years, dethroned them and brought Mrs. Gandhi back.
With a thumping majority.
With a thumping majority. Look, this is the strength of our democracy. I was not doing a political thing, my lord. Why get shaken when, my lord, some name comes or some surname comes? It's not always political. I'm saying this is the strength of the democracy. Lord, we may have aberrations. We may have some governors, my lord, we may have, who may have, my lord, not discharged their functions as expected of them. But since 55 years, as per the empirical data which is available, my lord, everyone has acted the way they are expected to act in a collaborative manner. And the best example was during COVID. Except, my lord, 1 or 2 states I'll not name, my lord, all states, Congress chief ministers, communists, everyone, they were on the same line. They were directly in touch with the prime minister and they were fighting the, my lord, crisis as a nation. So, my lord, we have a strong democracy and there are political dialogues, there are, my lord, political discussions and there are political solutions. But somehow, my lord, there is a trend, my lord, that now everything comes here. Now, my lords, may kindly see, my lord, after skipping through the, my lord, please come to page 765. My lord, My lord, I am arguing this, my lord, my proposition is this, my lord, that interpretation which amends the constitution, I'm sorry. No, remember, I have not come there. ये नहीं करना है next. Lord, 765, I'm not reading the judgment, but it says that A, I'm just giving the proposition, my lord, I'm not reading the judgment or my lord, my submissions. Textual meaning, if clear, textual meaning is always preferred. Yes, first principle, my lord, first principle of interpretation. Second, even in case of felt necessities or some extraordinary situations at times, your lordships would not interpret a constitution which even remotely has the consequence of amending it. There are judgments, my lord.
Certainly consider the interplay of 200 and 201 coupled with the sabbatical one and its proviso 1, proviso 2. These are very clearly interrelated. It is not a felt necessity issue. It's an issue. Constitution is a evolving subject, number one.
It's a living document, therefore they say yes.
Number two, not in the context of felt necessity as in an administrative law situation. In the constitutional concept itself, how do we gauge this proposition that you advance that at the outset the governor can straight away say that sorry, we will not assent to it. Withhold, in other words, the meaning you are saying, not to assent. So the moment the assembly passes the bill, it comes to the governor, he says, I will not assent the bill. That to be interpreted in the context of two intervening principles. One is the principle of federalism and the principle of democracy. Because in that context, we need to balance, both are as important as. There won't be an expression of a federalism written in the constitution, nor about democracy. How do we give the full import to a bill which is passed by the houses?
Yes.
And comes to the governor and solitarily he stops, or is there an obligation to ensure that a consultative process takes place? That when the bill comes to the governor, he could send it back with a message, and it gives assembly as well as the governor both get the recognition of their role to play. It goes back to the assembly, assembly considers the perspective of a governor who is reflecting perhaps in all probability the view of the center. And it goes back, assembly reflects on it, comes back. When it comes back to him, how do you read that position that shall not withhold?
He can still
Now,
refer.
nobody has addressed on that question as to when it comes back, he loses that opportunity to send it back to the president.
No,
Or it is just a thought,
I'm sorry.
just a thought. So do we also read 200 and 201 together?
We should.
Full flow.
Correct.
Even if it goes back to the president at that stage, he can't say no. So look at the beauty of the constitution. Even if in the second round it goes to the president can't say I will withhold it. President will have to say that he can assent or he has to compulsorily send it back.
But
When it goes back, when it goes back to the assembly and comes back again to the president, the constitution is beautifully silent. It says that it shall be presented again to the president for his consideration. Full stop.
the buck
The
stops.
silence of the constitution, enormous meaning it has,
Yes,
it carries. It is in that silence much more is there.
yes.
But to say that at the outset, the moment the bill is sent to the governor, he says, sorry, I will return it back, is a very difficult proposition to
Yes. Let me answer that. Let me answer that straight away. Lord, once, Lord, kindly take a hypothetical situation. And Lord, I'm aware of the argument that extreme examples are given by me. But before that, Lord, let me preface that. Lord, Constitution, I'm sorry, Lord. Lord, the constitutional interpretation has always been made based upon hypothetical and extreme examples. So when I answer the question, there would be some extreme example, but I want to give a prelude to that. Lord, when Keshwanand Bharti was being argued, and this is reported, Lord, I'll cite from that judgment also. The initial reaction, and my lords are, Lord, Mr. Sirvai, Lord, he has written, it's a first-hand account.
Making of the
Keshwanand Bharti case. He has recorded his accounts, my lord, what happened. And I think everyone should read that, my lord. Those, especially, my lord, those who are waiving the constitution, my lord, should read the entire, my lord, it's a 100-page book. What used to happen, my lord?
And it's very interesting.
Very interesting, my lord.
Some things we can't share it.
Your lordship, I also can't share it, my lord. And therefore, I insist everyone should read that book so that everyone gets the, my lord, meaning of the real democracy and real separation of powers. And those, my lord, who are abusing other institutions, my lord, would know, my lord, what used to happen. Now, leaving it apart, my lord, the bench was, my lord, prima facie of the view that if there is already a power existing to amend the constitution, why should we not permit the parliament to amend the constitution? The power to amend the constitution emanating under Article 368 can also include amending Article 368 itself. Why not? That was an argument, my lord. An argument was textual argument and quite, my lord, a catchy argument. Lord, Mr. Palkhiwala, my lord, it is reported contemporaneously, gave extreme examples and that turned, my lord, the table. What he said was that suppose Article 368 is so amended that the power to amend the constitution is given to executive. What will you do? Second, India, as per our preamble, is a sovereign democratic republic. Suppose some parliament were to surrender the sovereignty to the Queen of England. What will you do? Democracy would mean adult suffrage. Every adult will have a right to vote. Suppose a parliament comes out with a bill that only a particular section of the people will have a right to vote. Maybe those who are taxpayers or those who are graduates or those who belong to a particular religion. Because in those days, my lord, that was also one of the consideration when the partition took place. What will you do? So you will have to.
But earlier, prior to the constitution coming into effect, the voting rights were not available to everyone.
To everyone, yes.
They were not available.
They were not available to everyone. Yes, Manoj. So these extreme examples were given by Mr. Palkhiwala to convey that you are testing the constitution, not an enactment, an act. Constitution is a very fundamental document based upon which the nation subsists. So extreme examples are necessary to ensure that the constitution withstands any future extreme contingency. My lord, having said that, my lord, I'll answer your lordship's question.
But then you are arguing that the court cannot interpret the constitution in such a way that it amends the constitution. And what about basic structure doctrine?
It cannot.
No, the basic structure has been brought into only by the judicial interpretation.
Correct.
Otherwise, under 368, there is no such a provision that no such.
Yes, no, there is no requirement.
Yeah, so
Therefore, I'm saying the same thing with your lordship says.
So your paragraph.
No.
If I tries to argue
I'm
that
answering
the
my
courts,
lord.
that the courts cannot interpret a constitution in such a manner which would amount to amending the constitution. Then the basic structure has been brought out only by judicial interpretation.
I'm sorry, my lord. I'm not clear to your lordship. My lord, I was answering my lord Justice Narasimha's query. But I was not on this. Your lordships are right. What I said was that even basic structure doctrine came into existence because of extreme examples. that no, everything cannot be amended.
Basic structure first time came in Sajjan Singh,
Justice Mudholkar.
Justice J.R. Mudholkar.
Justice
He-
Mudholkar, my lord, your lordship, sir,
In minority judgment,
yes.
Justice Mudholkar and Justice Hidayatullah, they are part of minority. So Justice Mudholkar brought in basic features. Is it the constitution? If the basic features of the constitution can be changed, then would it not be amounting to changing the constitution?
It's not permissible.
And Justice Hidayatullah said that I would require stronger reasons than given in Shankari Prasad.
He said, I am not a grammarian or something, my lord. That's the expression Mr. Hidayatullah used.
Mr.
Justice-
Hidayatullah said that I would require stronger reasons than given in Shankari Prasad to hold that the parliament's power to amend the constitution are unbridled.
Yes. But my lord, point is, my lord, that the first time this theory was propounded or the word was coined by Justice Mudholkar. Thereafter, my lord, what point I was making was that it is lordships would interpret the constitution so that it can withstand extreme situations in future. This is, my lord, the basic document of the land. Now, my lord, answering my lord's question, my lord, suppose hypothetically, take for example, my lord, a bill is passed. My lord, normally, nobody would expect that the parliament would pass a law, my lord, surrendering the sovereignty. Parliament would never pass a law that taking away right, etc. But the examples were taken to examine whether such an amending power is there. I am giving a similar, my lord, extreme example. My lord, suppose a legislative assembly passes a bill that in my state, only one language will be used. People will not speak, use, or write anything in any other language. Language, my lord, would be within, my lord, list 2. The state has the competence. But it's not necessary that the governor will immediately withhold it or refer it or send it back. He may call upon the chief minister that this will destroy your economy. You do something. For example, some
You
state
are
where
on
to,
timelines now.
Hmm?
You are on timelines.
I'm not on timelines. I'm not on time.
That
I'm
has
sorry,
to
my
be-
lord, I'm unable to convey myself. I'm not on timelines at all. Forget timelines, my lord. I'm saying your lordship's question was that at the threshold he will withhold. No, it's not necessary that he will withhold at the threshold. He may have a consultative process. He can persuade them. My lord, suppose a part of the bill is repugnant to some central act. So rather than referring it to the president, he might call the chief minister and say that these 2 provisions are problematic. If you agree, I can refer it, I can return it to the house. You correct those 2 provisions. So, my lord, I was only answering your lordship's question that it's not that at the threshold he has to do it. It will have to be after a consultative process and for good reasons. For example, like in Punjab, my lord, he has done it, my lord, for a good reason. So he must have persuaded. And when, my lord, sometimes the political leadership in the state, that is Council of Ministers, have their own limitations, my lord. Irrespective of the party, they have to take a particular stand. There comes, my lord, the wisdom and, my lord, the power of the governor after consultation. If he feels that no, this cannot go ahead, then, my lord, he will have all the 4 options open, and therefore I would not read the power of withhold as a mere power of temporarily suspend his exercise and return it. But again, answering your lordship's last question, that what happens if he sends it and the assembly passes either with some modification, which may have the similar or other new problem, or without modification. Then also he does not lose his power of referring it to the president. They are not mutually exclusive. My lord, for that, would your lordship once again see, my lord, the chart which I have presented? Lord, that may, my lord, assist me, my lord, in making my point clearer. Page 820. Lord, it's in this very compilation, my lords. No, I'll answer, my lord, the first proviso, that it does not exhaust his all options. He can still refer it to the precedent. No, my lord, but for my satisfaction, please come to, my lord, that chart again. Page 820, my lord, it's in this very volume. For ready reference, my lord, the same chart which I placed, my lord, in a A3 format, my lord, is in a smaller version. The governor shall declare either. Your lordship gets, my lord.
Yes.
First option, grant assent, which, my lord, as I've said, 90% cases, it is happening. Withhold assent, second option. And third, reserve the bill for consideration of the precedent. Correct, my lord? Now come to withhold the assent, my lord, apropos, my lord, Justice Narasimha's query. There are two possibilities. At the outset itself, the bill falls through. I'll come to that. My lord, falls through, according to me, is the bill goes. The bill doesn't ceases to exist. But he resort to the proviso instead of withholding, bill is returned by the House to the governor with or without modification. Then, my lord, first proviso say he shall not withhold. It doesn't say he shall grant assent. And therefore, he has two options. Either he grants assent or he reserves the bill for consideration of the president. My lord, kindly visualize a situation where there is an apparent repugnancy. Well, there is an apparent repugnancy. Well, normally, it is expected that if there is a repugnancy with the Central Act, the Council of Ministers themselves would say that these two provisions are repugnant and therefore better to take assent of the President of India. That happens. That do happen. The Council also feels that for my state, this is necessary, that I also have a similar provision or contrary provision than the Central Act. So I would refer it to the President. So that can be done. But suppose the council genuinely feels, bona fide feels, that there is no repugnancy. The governor bona fide feels that two provisions or five provisions or any whatever provisions have repugnancy. He resorts to the proviso. Proviso says, now you have resorted to proviso, therefore your withholding option goes. Can assist you.
Mehta, just one
Please, Your Lordship.
information. The entire history of this country, has it ever happened that a bill has been withheld? A declaration has been made by the governor withholding his assent of any bill?
20 times in
No, 20 times it has been
withheld.
withheld.
From 70 till date,
Till date.
55 years, only 20 times.
Why don't you talk of 50 to 70? Why? You leave 50 to 70.
No, no.
You talk only from 70 onwards, right?
Lord, it's difficult, my lord, even from 70 onwards, difficult to find out all old records. 70 has no sanctity.
So, thank
So I said that you go back as far back as you can go in terms of collecting the,
20 bills have been declared by the governor to be withheld.
as we understand by all governments in past. Only 20,
20 bills.
only 20.
There was no formal declaration.
No, that is what I'm asking.
No.
Has there been a declaration by the governor?
There is a declaration.
Huh.
So 20 are those cases where the governor has said that I am going to withhold the bill, or I am not going, let us put it the other way. 20 cases where the governor has said, I will not grant assent for ABC reasons.
No, he would say, I withhold the bill for ABC reasons.
Same expression.
Same expression.
Same thing.
Your lordships are saying in a positive way, I'm saying in a negative way.
There are.
But since declaration is either of the three, he cannot say, I'm not granting assent, but he would say, I'm withholding. But there is a declaration. There is a declaration made for all four contingencies. So therefore, I was trying to suggest. Therefore, my lord, I was trying to suggest that that felt necessity argument is not, my lord, something, my lord, apart from the time limit. Time limit also, my lord, therefore, I wanted to say that maximum is 1 year, and that also, my lord, about,
Not a thought, but just a doubt.
yes, my lord.
When the bill is sent back with the message, I think parliamentarians will be able to tell us better. When a bill is sent back with a message, and then the assembly amends it and in entirety of it, completely new sections are added, altogether completely changed, and then comes back. Under the parliamentary procedure, does it continue to be bearing the same number as a bill, or is it a new bill?
Same number.
Same number. So therefore, Therefore, when it
I
comes
would
back-
not go by my learned friend's experience, but
when it
same-
comes
I
back-
will check up and answer, my lord, so far as I'm
when it
concerned.
comes back, then is it, even in a case where the completely act is changed, is it a case where only the proviso will apply?
My lord, in Tamil Nadu, it was a separate number.
Just normally it would not happen, Mullah. I mean, that's again a hypothetical.
Principle, as a principle, so
Mullah.
it comes into the hands of the governor as a new bill,
No, same bill.
same bill, even if it is completely
Yes,
changed.
But
even
I
it's the
will
same.
answer, my
Only a
lord.
The
question.
bill is exactly the same. Mullah.
No, bill,
Because a new bill would be to withdraw that bill and introduce another bill. That's how it's a new.
Therefore,
no, 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 no.
But
I'm
that
sorry.
bill, the number doesn't change, Mullah. So we've done it several times.
No, my lord, subject to correction in case of Tamil Nadu, and I'm not going into the facts, when it was returned and when it came back in a new number or possibly the old number. I'll just check up and answer, my lord. I don't wish to hazard. my lord.
In my experience, Mullah.
Just a thought, just a.
No, no, I go by
If I had
my friend's experience, my lord. I don't have first-hand experience, but I'll take instructions, my lord, if there is anything.
And I've
from-
never heard, Mullah, we never get a message that I'm withholding the bill. At least that declaration I've never seen.
Therefore, I ask this
No, no, no,
question.
I'm sorry.
The governor is
Yeah.
sitting over it and he
I've
withholding,
never
withholding, or he makes a declaration
Yes,
that I'm
it is
withholding it.
not part of any record that any formal declaration is made, at least.
Just like a declaration made to grant.
Sorry,
assent,
but
is there a
sorry.
declaration to-
No, he just sends it back. He just sends, there is no declaration. The act itself is a declaration.
Lord, my learned friend is, my lord, misconstruing my submission. He says, I have never seen that bill is returned to us. First of all, Parliament is never sent that bill. It is the assembly. Number two, assembly is also never sent the bill that I withhold it. So he withholds, that's all.
Withholding has to be done by the governor, not by the assembly.
Exactly, that's what, my learned friend says parliament
No,
never
no,
come to
Even the
know
president sends
that-
back the bill with the message. It's not, it's the same thing, but there's no formal declaration is what I'm saying.
No, that
My lord
is-
asked that question, I answered.
That's the
The act itself is-
constitutional requirement. Declaration is the constitutional requirement. You have to declare.
Well, just one clarification. If the bill comes back and if there is no amendment made and the same bill is sent back, it will come back as the old bill. If any amendments are made, well, I'll reconfirm this tomorrow, but if my understanding.
When the bill comes back, the language, that's why the constitution has used different kind of expression. When the bill
Message.
comes back, it comes with a request, with a message
Correct.
requesting the house to reconsider.
That's correct.
So the message will have a reason.
Correct.
Message
Yes.
will have a reason. Based upon that, the house will reconsider.
Yeah, exactly.
The shall declare and request with the message are two different kind of expressions used in the
So if
constitution.
Your
the
lordships are
message-
right.
But if the
Both
message-
will have to coexist.
But if the message is considered favorably by the house and the house makes amendments,
Correct.
then it might come back as a fresh bill before.
As a new number.
I'll confirm it tomorrow.
But I will also confirm, my lord, I don't want to hazard guesswork, my lord. I will confirm, my lord, but possibly it goes as a separate bill. Or with a message that we have not considered the suggestion, or we have considered partly, or we have completely changed the bill or whatever, my lord. I'll check up, my lord. There must be
I
something.
don't want to interrupt. Sometimes happens, well, the Lok Sabha sends it to the Rajya Sabha. Questions. And then the Lok Sabha sends it back. It's not a new bill. We've experienced it so often, Malas.
quite
Because those, it's not a new bill, that's all. Maybe, Malas, that the assembly here is different, I don't know, but that's our experience.
The amendment is carried out pursuant to a message.
The better to take instructions rather than arguing.
Rest of the business rules will tell us.
Yes,
That's right, that's always.
yes, please.
Parliamentarian on your side.
No, my lord.
There is.
We are all only lawyers.
Then send money.
No, there's a parliamentarian.
There is.
Yes. But yes, he was a parliamentarian.
Mahesh Jetmalani was a parliamentarian.
Yes, yeah. Experience.
I can begin tomorrow, my lords.
Take the time between you and the learned attorney
Look, we will,
by 1 o'clock.
I'll at least take an hour.
Huh?
I'll at least take an hour.
No, we'll conclude by 1 o'clock. So you decide amongst yourselves.
I'll ensure that he gets, my lord, his time. There is no, we will act in a collaborative and
You
consultative.
act in a collaborative, consultative.
And I am bound by his aid and advice.
And he will be a guide, philosopher and friend.
Therefore, I am saying, my lord, I am bound by his aid and advice. And he is a dual role, friend, philosopher and guide, both.
My application
Then
should be
take-
formally taken on the record. My intervening application has to be formally taken on record.
Has been withheld.
Pardon, my lord?
Get one of the declarations made by the governor where a bill has been
Has to be
withheld.
allowed.
I'll try and get.
You try and
Because-
let us see if there is something.
Yeah, it's possible.
Yes.
Very good.